Thank you much. I think you can hear me, yeah?
Yes.
Thank you very much. Thank you, Professor Baldi. Thank you for the floor. Greeting to everyone. And thank you for the opportunity to talk about data ownership on this forum. So, data ownership, where we are and where we are headed. Important questions today. The data economy and the digital data and data-based assets traded within it is built on digital data. The existence of data economy and data trading evident. At the same time, property rights are a fundamental feature of both the economy and commerce. It follows that property law regimes must also respond to this phenomenon, which entails the property law adaptation of digital data and database assets. By digital assets, we typically mean cryptocurrencies, tokens, and NFTs, which play an important role in today's digital markets. However, the broader universe of digital assets, together with data and database assets, is far more diverse and continues to expand, including digital data themselves, which are traded, for example, for data research purposes. The concept of digital assets, therefore, needs to be understood in a wider sense. The economic relevance is increasing both at the level of national economies and globally, while legal regulation worldwide continues to face persistent challenges, especially as regards their treatment within property law. With a few exceptions, the law still does not trade digital data and database assets as a part of property. Rather, only the rights relating to them and are typically recognized as an element of property. The rapid diversification of digital phenomena contrasts sharply with the law's limited conceptual capacity to capture and regulate them. Although the regulatory approaches vary significantly across legal systems, they remain fragmented and lack coherent conceptual framework capable of reflecting the complexity of digital phenomena and structuring them into consistent regulatory narratives. The underlying problem is not regulatory diversity, but conceptual misalignment. Digital data and information are treated as interchangeable, each being interpreted through the other, while legal narratives emphasize the informational characteristic of digital phenomena. As the existing regulatory narratives, largely because they approach digital data phenomena through the lens of information, typically classify them as intangible assets. Yet, digital data themselves are distinctly physical phenomena and, based on their intrinsic properties, do not belong to the set of intangible phenomena. Rather, they should be placed in the category a kind of tangible or physical assets. This conceptual deficit constitutes a major obstacle to effective regulation. It is particularly evident in the persistent difficulties surrounding the property law treatment of digital data and data-based assets. Data definitions in the European Union's key data regulatory instruments are consistent, but they explain data through the lens of information and therefore cannot distinguish adequately between the two concepts. You can see here data definitions in the European Union's key data regulatory instruments, for example, GDPR, Data Act, Data Governance Act, indirect regulation of data as a commodity, focus on goods that contain digital data, digital content, or digital services, rather than on the data itself. Is comparing early principles and UNIDROIT approaches about data and electronic record, it means also information. It has already been demonstrated that information-based regulatory regimes, such as intellectual property law, data protection, and privacy rules, are not suitable foundations for establishing ownership rights in digital data, while contract law can offer only inter partes protection, not ergo omnes security. None of these approaches has produced meaningful results. It should nevertheless be noted that all these regulatory frameworks can be regarded as rules that would restrict data ownership if such ownership were introduced. In other words, they already exist ownership restricting regulations awaiting the emergence of data ownership. At the same time, Article 345 of the Treaty on the Functioning of European Union teases EU's hand with respect to harmonizing property rights, as it provides that the treaties shall in no way affect the system of property ownership in the member states. This explains why European regulation has moved towards the creation of data rights rather than recognition of data ownership. So we are waiting in vain for European Union level regulation of data property. It follows the direct property law regulation of digital assets remains, in principle, a task for member states. Accordingly, within the regulatory architecture sketched on the slide, one would search in vain for explicit references to data ownership. And at this point, all of us, not only civil law but common law as well, run into a conceptual doctrinal problem. The law has not yet developed a complete conceptual toolkit for digital phenomena that would allow it to interpret digital assets effectively in light of the diversity of legal system approaches. In short, we are still not able to articulate digital phenomena with sufficient precision for legal regulation and for coherent regulatory narrative. And at this point, it's necessary to step back and examine what digital data and information are in fact and what distinguish them. The epistemological basis of my approach is physicalism, which gained prominence in the 20th century alongside modern physics. I consider this shift in perspective important here because scientific progress enabled us to observe and to make practical use of physical reality in far broader ways. This goes hand in hand with the fact that we increasingly extend our dominion, yet human control, to regions of the physical world that we unknown or at least not technically accessible when many of today's prevailing legal concepts and categories were formed and became entrenched. With regard to the subject of my presentation, I'm thinking in particular of the still prevailing conceptual frameworks implicitly shaped by Newtonian picture of the world, behind categories such as thing, Sache, and thing in possession, and material, immaterial, tangible, intangible classification. In my view, this framework should be supplemented and updated from a physicalist standpoint. Digitalization is produced of the 20th century, and it could not exist without human being able to control electromagnetic phenomena, to stabilize them, store them, transmit them, and shape them. The discrete units, this stabilized, encoded in binary form, stored, processed, traded globally, and used, are what we today recognize as digital data, a fundamental component of the digital realm's phenomena. Since digital data and digital information originate within the domain of data and information theory, let us step into that domain for a moment to clarify what we mean when we refer to digital data and digital information. So, you can see on the left side digital data, ones and zeros. Digital information is the result of the interaction between digital data and the human brain. Information is created when humans interpret, understand data. Each specific piece of digital information is always grounded in a fixed data context that cannot be interpreted in other way. E.g., an image depicting a sunflower cannot be interpreted as the text of a poem. So, again, data, a human brain, contact between human being and data, and this is information, and knowledge, and mastery, and wisdom. The Ecoff's model in another approach. And by digital data, is an independent entity of physical reality, existing independently of human perception and legal recognition. Information is a phenomenon that arises and exists only through the interaction between data and the human mind that interprets it and therefore cannot easily be understood independently of the human individual. It is thus not surprising that many legal approaches to the digital phenomena from the perspective of information are grounded in personal rights and consider it as intangible object. Treating digital data and digital assets as property requires more than analogy. It requires alignment with the foundational principles of property law. In comparative terms, there is no single uniform system of property law across jurisdictions, but many legal systems really on broadly similar underlying principles. In general, an asset should be definable, identifiable by third parties, capable of being held, controlled, or transferred by third parties, sufficiently stable or persistent, economically valuable. Property regimes typically presuppose features such as erga omnes effect, exclusivity, transferability, at least in principle, publicity, transparency, and depending on the system and the asset, embodiment, corporeality may also matter. The principles of numerous clauses and publicity are widely regarded as characteristic features of property regimes. Applied to digital data, these principles can be satisfied, therefore there is no general reason to exclude digital data and database assets from the domain of property, of personal property, property rights, unless a specific information approach policy reasons requires exclusions, e.g. personal data, confidentiality, overriding information, governance, regulation. If digital data can be object of property rights, then many data-based phenomena can, in principle, fall within the property sphere, subject to limits and competing legal regimes. It will be in Occam's razor style approach. Breakthrough, common law in advantage. In contracts involving digital data and database assets, it is common to simulate ownership rights within the framework of contract law, whereby the parties attempt to compensate for the absence of ownership regulation on an inter partes basis. The disadvantage of this approach is that it operates only within the legal relationship between the parties and offers no protection against third parties. The first breakthroughs can be observed in the fields of money and securities law, where special approaches have emerged, e.g. Germany, Liechtenstein, Belgium, France, often under the concept of value right. Two typical examples of breakthroughs in Europe, a kind of hacking of civil code, sectoral regimes are bringing tokenized database assets within the property system, the German Electric Securities Act, and the Code Monetary, the French Finance and Monetary Code. Despite these developments, there remains no general private law recognition of digital data, and to a large extent, database assets as object of ownership or property. Even the most flexible regulation in this area, such as the Austrian Civil Code, ABGB, property law provisions, raise questions regarding the quality classification and scope of legal protection of data and database assets. And now, common law legislation are already ahead. The Property Digital Act 2025, December, adopts an explicitly agnostic approach. The text you can read on the picture. It's very short. By doing so, the Act deliberately refrains both now and for the feature from the classic closed category classification of phenomena capable of functioning as object of personal property, and it likewise refrains from defining the concept of data and information. In other words, it opened the door without trying to settle the definitional debate. That said, the digital assets, whether data or database asset, can only be an object of personal property if it also satisfies the general criteria of property, i.e. the usual principles of property. It must be definable, identifiable by its nature, capable of being held, etc. The Act effectively aligns such phenomena with the logic of numerous clauses, not by creating a new exclusive category, but by ensuring that digital electronic nature is not in itself a disqualifying feature, yet it opens up the possibility of falling within the set of things that can be object of personal property rights. In practical terms, the judge no longer has to decide whether digital data or any database is capable in principle of being property, because the Act has already answered that question. The judicial task shifts to deciding whether, in the particular case, the digital phenomena must or may be excluded from the object of property for some other reasons, for example, because it constitutes personal data. So practitioners are awaiting further judicial guidance. However, this solution is of limited use in code-based, civil law regulatory system, in civil law settings where property regulation typically requires a conceptual definition of the object being regulated. So a property regime for digital data and database assets would require a concept of data that can be applied independently of the concept of information. The explanation of these concepts will be the subject, maybe, of another lecture. At the end, what we gain from the property law regulation of digital data and database phenomena: conceptual clarity, distinguish data from information, eliminates dogmatic uncertainty. Entry of property law into the digital domain. Data and database assets can be clearly classified as part of the property estate. Enforceability, stronger legal enforcement, including tracing, recovery, and restitution. Market confidence and stability. Predictable legal status leads to lower risk and greater investments within this. Financial capability. Database assets can be used as collateral, held in deposit, or serve as object of assets management. Insolvency and succession compatibility. Such assets can be included in insolvency, bankruptcy, and inheritance proceedings. Finally, it should not be overlooked that, as a consequence of the social function and obligation inherent in ownership, these assets could likewise become subject to the property-related social obligations accompanying ownership. At the end, maybe, if everything is going well, the question of ownership may not seem so pressing, but it becomes much more important to be able to rely on property rights in data when our rights are violated. Thank you for your attention.